Hello, everyone. This is the last session before roundtable and before lunch. As a chair, I will be very brief. I will not pay attention, but I have to express my gratitude to all the organizers, especially to Professor Nilay and Professor Abdurrahman for the invitation. And it's a great honor and happiness for me to be here, just because I've passed almost 25 years of my life here at Istanbul University as a student, as a research assistant, as a professor. Finally, now I'm at Bilkent, Ankara, but here is my alma mater, as I said, always. And great to be here, great to be with you, with my colleagues, friends, and students, old students, new students. And great to chair this wonderful session with my colleagues and 4 distinguished speakers about transdisciplinary and translational issues. And I will be very brief, and I will begin to present my first speaker, Professor Cristina, who will be online. Actually. Hello, Professor. Can you hear us?
Yes, and you can hear me?
Yes, very well. And you can see with the audience also. And Professor Cristina, I hope that I can pronounce well. My Italian is awful, but is Professor of Comparative Private Law at the Law Department of the University of Turin in Italy and the Georgetown Law Center for Transnational Legal Studies in London. She will present a very interesting topic: who is responsible for ChatGPT's wrong legal advice? And the floor is yours, Professor. Thank you very much.
Good morning. Good morning. Thank you very much for the invitation and for having me less remotely. My presentation today, I hope you can see my slides. I have some slides.
We will. Yes, now we can see your slide.
Make them bigger. Okay. So my talk today is about a very basic question, but I think it is a very good case for a wider discussion about LLMs, large language models, and how they are actually shaping and reshaping the law and the way we live. So this is perfectly aligned. This connects with the research projects we have in my university and in my law department. And just to share with you that we are working on different projects, but I think 2 projects are particularly relevant here. One is about legal tech for social good, and the other one is about how we can reshape legal education for tomorrow's European lawyers. We have been happy to have a first output of the research in this book by Art, Future-Proof Legal Services, that is just out. So this topic perfectly aligned with what I'm currently researching on. First of all, I think let me start with an interesting piece of empirical research. Here you can see an article that is mentioned, talking about interdisciplinarity, transdisciplinarity. Is an article analyzing, by using experimental method, the approach of the people to LLMs. And according to experiments, the authors have been carried on in these cases. They explained their experiments in a recent 2025 conference. It seems that lay people can distinguish LLMs from lawyers, but they lack asking advice to LLMs, and they still favor advice from an LLM if compared to the advice of the lawyer. Of course, this is a matter of concern for us, a matter of reflection. I think these researches that coming from psychology, sociology, show that people can understand when it's human and AI, and this is positive, but the fact that they still prefer it because it's fast, it's confident, it sounds very human, but it is not so. Of course, this also shows a gap between perception and reliability, where we are talking of legal and ethical questions that can be very much related to our fundamental rights. So, given that this fact, I think the first point I would like to stress here is that we have to be aware about the difference in between the technical reality and the narratives about LLMs, because there are a lot of narratives that are, of course, are fueled by this new economy that tend to represent LLMs as very much human or anthropomorphic tools, trying to hide the reality. The technical reality is that ChatGPT is just a statistical engine, that is to say, no basic legal reasoning or deductive logic, the kind of logic we can expect in providing legal advice. It is not a reasoning entity, it is just an engine, and it is based on statistic and probabilistic methodologies and correlations. And the way it uses and is trained on data remains opaque. It's very difficult to verify the inputs to this machine, and of course we know, it has been said already, in many cases it can conduct to hallucinations. That is to say, in this field, something that is false, it may sound real or something you can trust, but it is entirely false at the end. So when these systems are used in the specific case, it also seems that I read one case that we had in my city, that is Torino, that is very recent. It seems that not only lay people tend to rely on LLMs, but also lawyers. In Turin, we had a decision in September by the legal section of the Turin Court, and it was actually a case of misbehavior by a lawyer that has been writing a legal claim by relying on, it seems, according to the judge, the ChatGPT, because it was full of incoherent sections or abstract and related citations. So the judge has been capable to find out that it was supported by an LLM, and of course, because of this, the lawyer gets sanctioned according to the Italian Code of Civil Procedure and the professional rules of diligence. This is not best practice, of course, but the case is very recent, and it has, of course, attracted a lot of attention from people in my country. Legal advice, what I mean for legal advice, we are talking of wrong legal advice. It's advice about legal rights and obligations for a specific case and context. I'm not talking about vague legal information or general commentary. I'm talking of something that is personalized. Of course, in the new jurisdictions, only qualified lawyers, in principle, are permitted to give legal advice or to represent clients or to guide clients outside the domain of the legal profession. We are in the area of unauthorized practice. But anyway, people still ask for. And the first question is, we have in the EU, as you know, a quite comprehensive model for approaching AI liability. We have the EU AI Act that has been actually passed in 2024. It's the first comprehensive framework for regulating AI systems, different systems. It applies to AI systems on different risk levels: unacceptable risk, high risk, limited risk, and minimal risk. So depending on the level of risk and the risk assessment, there are different provisions, different options. And it stresses that providers and as well the providers of the AI system have obligations that range in between risk management, transparency obligations, and post-market monitoring obligations. And of course, there are sanctions, including fines and precisely fines. There can be significant percentage of the turnover of the company involved in the misconduct, incorrect or misleading use. Much remains to be said, honestly, because in practice we have in this period adopted the code of practice. practices about how to implement the principles in the UAI. We already have one code, and we are now working on a code about transparency rules. So the Commission has launched a consultation that is open in these days. We have also tried to give some input about the new code for transparency. Of course, the implementation is essential to see how, if it works, it is effective. Of course, it's useful to have the concept of provider, deployer, and user and distributor. So we have now concepts that have been defined by within the UAI Act that helps to allocate the duties. The European approach to AI liability also include the new product liability directive that complement the AI Act. And there is in the directive, the new one, 2024, just entered into force, a new definition of what is a product, essentially to include software and AI, certain kind of AI systems when they are part of software as well, and a new interesting redefinition of the boundaries of the concept of physical and non-physical damage. So this is a new approach to AI liability. The question is, could wrong legal advice be classified as high risk, or a legal advice AI tool be classified as high risk system and be subject to a quite severe regulation and fines in case of misuse? Again, another open question is the gray zone, how the notion of product liability will be interpreted by the European courts in adapting to AI systems. Is this legal advice when wrong a misinformation or a misleading output? So we can also say that consumer protection rules under new law can play a role here. Of course, the main problem remains that we have certain gaps that I identified in these main issues. For example, assessing it's often hard to show that a specific error by ELN is something that you can foresee as a provider and to think about how the machine works, because it has been said before, it is a pack, so it's the issue of causation enforceability. Of course, there is a complexity and the black box nature of this machine, so it's very difficult to analyze. But I'd like to stress one point specifically that is much relevant here, the issue of the fragmentation of the supply chain, the fact that we have many actors that contribute to design, develop, fine-tune, integrate, and contribute. This is a scheme that I have prepared, and it is clear about the attribution of responsibility and the different conceptual models. So we can fix our attention on different actors. The developer, the model provider, that could be, for example, OpenAI, the deployer, someone who is integrating the party that puts the model into use. For example, a legal tech startup that integrates ChatGPT into a legal advice interface. The platform, the intermediary, that can be, in the case issue also relevant, when you have a platform that is hosting the AI tool, the user and responsibility of the people, and then the issue of the role of the lawyer in providing oversight to supervise the AI input, so the lawyer, of course, is into a specific case involved. And potentially the role of the insurer when the liability is allocated through insurance within the AI sector. So as you see, the conceptual models to attribute responsibility are fragmented into a long chain. What we can imagine if we think policy options we have. For sure, my point is to stress that I believe that legal advice systems should be regulated within the AI Act, and they can be classified as high risk. You have to deal with very sensitive areas of our lives in terms of rights. But we can think to other policy options that we have. And this is not EU only. I mean, this is something we can reflect in a comparative perspective, in a disciplinary perspective. So we can, for example, require AI advice systems into the legal domain to undergo some sort of validation by qualified lawyers. the question here is, are we over-lawyering? So if we assume lawyers have to be gatekeepers, are we expanding the domain of lawyers to the detriment of these AI-based tools that to a certain extent, when they do correct advice, correct illegal information, can expand access to justice, the providing information to citizens very fastly and rapidly, but I mean, do we expand the role of lawyers as the keepers of the system, assume that lawyers have the competency to do so? Shall we consider licensing or certification of legal AI systems? So if only certified systems can produce legal value? For sure, according to the EU AI Act, there's also a policy option and it is also mandatory to design a system of monitoring and auditing and tracing how these errors can be traced and audited from the AI system. And one thing that I think is absolutely essential in policy design is to include disclosures, and this is already so according to the new legal framework, so people have to be informed about the risk. They shall be asked to give consent to be helped to overcome biases and to know about the risks they are taking. And of course, the discussion can also focus on the role of the human in the loop in this process. So as the AI system is giving advice, how you include a human in the process. This is something that the EU legal framework stresses substantially. But how far is possible for a human to oversight this process? To conclude, just a few points on my side, based on these case. ChatGPT wrong legal advice is not simply just a technical fault, it's a mirror. It's a mirror that is reflecting how law, expertise and trust are being redefined today. The real question is not only who is responsible, but how responsibility is evolving with respect to statistical reasoning. I think to strict liability as an option, because we are dealing with statistical reasoning. And this is a way to redefine responsibility and liability rules to a different reality. And to conclude, there is a point that is important. If lawyers have to be the gatekeepers or validate the result of this sort, or are called to do so for the benefit of society, there is a big issue of competency. Because, of course, we today do not train our students in this perspective. We train students according to very traditional path. We try to innovate in every faculty, and there are examples. But I think we're just at the beginning in giving competency to the future lawyers, the junior lawyers, to manage a future that I think will be complex and critical. Thank you for your time and attention.
Thank you very much, Professor. And thank you for respecting your time. It was wonderful. And as a tort lawyer, I totally agree with you. It's a mirror who is responsible now. It's a big challenge for all tort lawyers now. Thank you for this wonderful speech. And now I will pass to my colleague, Dr. Nilay KUZEYLI. Actually, probably when she sent her paper for the co-paper papers, she was still doctor at University as a part-time. Now, as her dean, I'm very proud to say that she is a full-time professor now at University Law School. We are working together, and she will present now AI-powered tax governance within rights, risk, and regulation.
Dear Professor, dear participants, before I start, I would like to express my gratitude for the opportunity to be a part of this wonderful symposium. And it's specifically meaningful for me to present my paper under the moderation of Professor BAYSAL. Let me start with explaining my agenda today. I will start with framing the problem, which is the text gap, and then I will move on to how artificial intelligence is currently being used by tax administration around different jurisdictions, and I will highlight the risks and legal concerns, and then I will provide some recommendations for responsible use of AI. The fundamental problem in tax law is tax gap, and we can define tax gap as the difference between the tax that should be collected and what is actually collected. And there are several reasons behind tax gap. First is compliance is not always straightforward. Even if you want to pay your taxes, it's not always straightforward. Even when someone wants to pay their tax, there are still many steps involved. They need to calculate your income, you need to decide whether you are within an exception or not, and then you need to keep your records and everything. It's not easy, it's a burdensome process. So this is the first reason. Even if you want to pay your taxes, it's burdensome. The second reason why there's a tax gap is we face deliberate tax evasion. Individuals or companies that actively seek to avoid their taxes. And this constitutes the majority of the cases. And with the rise of technologies like blockchain, crypto assets, it's even better for them, even easier for them to conceal this evasion. And the third reason behind the tax gap is tax authorities operate under the resource constraints. And tax administrations do not have unlimited resources. Their workforce and operational capacity is limited. And as a result, audit rates remain very low in most of the jurisdictions. For example, in Turkey, audit rate is 2%. Which means only 2 taxpayers out of 100 is audited. And it's also relatively low in most of the jurisdictions, and it's not higher than 5% in the United States. So what can be done about this problem? Increasingly, governments are using AI in tax administration, and they're asking whether AI could offer part of the solution by reducing administrative burdens, improving targeting, and enhancing compliance. And according to OECD's report in 2024, the use of virtual assistants and AI in tax administrations has nearly doubled since 2018. And according to a very recent report from OECD, it's very recent, 29 out of 38 member states currently report AI use in their tax systems. Let me now explain how AI is being used in tax administrations. It's mostly used in the detection of tax evasion and fraud, and also it's used to provide virtual assistance to taxpayers. I categorize AI applications in tax administration into 2 main domains. First is taxpayer-facing services, and the second is internal compliance operations. Taxpayer-facing services are designed to assist taxpayers fulfilling their obligations, especially those who are willing to comply but find this process difficult. For example, many tax administrations have adopted AI-powered chatbots, virtual assistants, or e-filing systems that guide users through their declarations, check the eligibility of their deductions. And these are increasingly being powered by LLM models and personalized interfaces, making tax compliance much more user-friendly. And then we have the second category, and the second category is the internal compliance operations, what might be called as back-end systems. These are primarily used for identifying non-compliance and improving administrative efficiency. They include risk profiling, fraud and evasion detection tools, and predictive analysis for data collection and enforcement. Here, AI is used to detect patterns of behavior and anomalies that might signal fraudulent or evasive activity. So first category focuses on the facilitating the compliance, and second category focuses on detecting non-compliance. I will start with the common AI deployments for taxpayer-facing services. It can be said that these are mainly designed for the taxpayers who are willing to pay their taxes. As I mentioned before, complying with tax laws is not easy. We refer to overall challenge as taxpayer compliance burden. And it includes both the time burden and financial burden. And when we look at the traditional support models, they are bureaucratic and time sensitive but slow, so that they are not working properly. And many tax administrations, because of that problem, are using AI. And these systems are designed not to replace human judgment, but to reduce administrative costs in the tax administration. So ultimately, by doing so, they can increase taxpayer satisfaction and voluntary compliance by making the entire tax system more equitable and more efficient. So now, let me now turn to the first category of taxpayer-facing AI tools, rule-based virtual assistants. These are relatively simple systems designed to answer routine tax questions using predefined logic. The system relies entirely on the pre-programmed rules. For example, imagine a taxpayer asking, it has been 8 months I'm living in Turkey. Could you tell me if I'm a resident or not resident in Turkey for tax purposes? And the answer is pretty straightforward. If you are staying in Turkey more than 6 months, you are, yes, resident for tax purposes. If it's not still 6 months, then you are not regarded as resident for tax purposes in Turkey. But the problem with that application is it cannot interpret or generate responses beyond what is already coded in the system. And that's why most AI experts actually don't classify these rule-based programs as real AI. But it does have that value, especially in automating routine and mundane tasks. It helps tax officials to focus on more complex cases rather than spending time on repetitive, time-consuming inquiries. As for the risks, the main concern is that taxpayers may over-rely on these answers, but the risk can be managed, for instance, by making it explicitly clear that the assistance replies are not legally binding. So now let's move to second type of taxpayer-facing AI tool. These are far more advanced than simple rule-based systems. They understand complex, nuanced questions and generate context-aware, fluent answers. So let me give you an example from Singapore. In the Inland Revenue Authority, their revenue authority, deployed an LLM-enhanced chatbot, and they upgraded it in 2023. And now it's not only answers questions, but it also allows taxpayers to perform authenticated self-service actions like checking balances, making payments from the system. However, these, according to their data, the Singapore Revenue Administration's data, in just 1 year, the chatbot handled over 70,000 transactional queries, and it saved more than 11,666 hours of taxpayers. So it's a major efficiency gain in tax administration. However, as we all know, LLMs also come with serious risks, and most notably, they can hallucinate and they can generate confident but factually incorrect answers. Third, we have pre-filing tools. And this perhaps is one of the most powerful ways to reduce compliance burdens. A strong example comes from Australia. And Australian Taxation Office uses data from employers, banks, government institutions, and to pre-fill individual tax returns. Taxpayers still need to review and validate the information, but it reduces human error, speeds up the filing, and increases trust. The ATO also uses real-time prompts. For instance, if when you are filing your tax return, if there is any mismatch in the tax return, the system immediately warns you, and you need to correct the mismatch in filing your tax return. And in only 1 year, ATO issued 636,000 such kind of prompts, and protecting nearly 79 million of Australian dollars in revenue. All 3 of these cases show that AI can improve both compliance and user experience. Now let's turn to the second category, which is AI applications for internal compliance operations. These tools are primarily used by tax authorities to identify non-compliance and detect tax evasion. As I mentioned before, tax audits are the core element of the tax system, but they are not sufficient in most of the jurisdictions. And because tax administration has limited resources, here AI can help. Tax administrations now hold unprecedented volumes of data in their care. And this data comes from transaction reports, third-party reports, digital filings, and even they can collect data from our social media accounts, from web about us. So using that data, tax authorities can first risk profile the taxpayers. And a practice stage is actually a practice they've been always using, but now with the AI, they can use this with much larger scale. And machine learning models can process millions of data points and flag anomalies and inconsistencies and help officials prioritize their riskiest cases. But this also introduces serious risks. A dramatic example comes from Netherlands. The Dutch tax authority used an algorithm to detect benefit fraud, child care benefit fraud, but it was trained on a biased data using nationality and postcode as a risk indicator. If you have, let's say, dual nationality, if you don't have an ordinary Dutch name and surname, you are flagged as risky taxpayer. So what is the result? Over 26,000 families were falsely accused of fraud, and many were dual nationals or from immigrant backgrounds, and the system wrongly flagged them, and they were not given the benefits. And the false positive rate of the scandal is 94%, which means out of 100 people were entitled to a benefit, but 94 people were not given the benefit, and they were accused of fraud wrongly. And this scandal shows how AI, if not carefully designed or monitored, can lead to a devastating real-world harm, especially in sensitive areas like tax enforcement. Another common use of AI is evasion and fraud detection. With so much data available, AI systems can detect suspicious behaviors, flagging inconsistencies that may indicate evasion. For example, let's say I am traveling all over the world and I am constantly posting my red flashy Ferrari on Instagram, but I only declared $30,000 in a year. So that may flag up some inconsistencies, and the system might flag this as a discrepancy and trigger an investigation. And a striking real-world example comes from France. Under French law and under many different law systems, tax law systems, you need to declare the additions to your property if it's increased the value of your property. And in French, you need to declare if you have a swimming pool to give the accurate tax basis. But people do not generally declare, so to detect the undeclared pools, tax authorities use AI and aerial imagery. The outcome, over 120,000 undeclared pools were discovered, generating 40 million euro in additional revenue. Sounds impressive until you look closer, because the system had 30% error rate. It often mistook solar panels as pools and missed some of the pools hidden under the trees or shadows, so it's not accurate. Even more concerning, it was only deployed in the mainland France, not in the Corsica or overseas territories. And in 2023, the French Court of Audit criticized this as a form of unequal treatment, violating the principle of equal scrutiny for all taxpayers. And finally, AI is increasingly used in debt recovery. Here, predictive models analyze taxpayer data to identify who is most likely to pay, when they are likely to pay, and what kind of interventions will work the best. So risk profiling systems are designed to answer who should be audited, and fraud detection algorithms are used to determine who has committed an unlawful act. And the predictive debt collection models help us to help tax administrations to determine from which debtor when the tax can be collected. And now, now that we look at how AI is being used, let's turn to the common risks, legal concerns, and recommendations that arise from these deployments.
5 minutes.
Okay, I will finish it in 5 minutes. I will focus on only 3 key areas. First is inadequate or low quality data. And the quality of data used in AI systems is foundational. If the data going in is flawed, if it's incomplete, outdated, or biased, then the AI outcomes will also be flawed. So that means inaccurate predictions, misguided risk models, and potentially discriminatory results. This is especially damaging in taxation, where the decisions affect people's legal rights, economic well-being, and public trust. The recommendation here is to improve the accuracy and fairness of AI systems in tax administrations. Professional tax experts should be involved in the AI training phase, and oversight by human experts is needed. We need to keep the human in the loop through the AI lifecycle. And a great example is from German fiscal code. Let me read this provision. Maybe I will only explain the provision. It's from Abdurrahman, Article 29, C5. It starts with revenue authorities may use automated systems. I think it's very important, because legislative power is letting administration to use AI. This provision clearly affirms that automated decision-making systems must remain subject to human oversight and cannot replace human judgment entirely in the administrative procedures. And specifically, the law sets out minimum safeguards that any risk management system used by the tax administration must fulfill. First, random sampling must be ensured. A sufficient number of cases must be randomly selected for human review. And second, human review for flagged cases. Cases flagged as potentially risky by the system must be reviewed by the tax officials. and this prevents fully automated decision making and preserves human judgment. And the third, manually case selection by officials. The system must not limit the authority of the tax officials. And fourth, regular evaluation of the system. This ensures that the system meets its intended goals and does not create system bias or inefficiency. This provision offers a model legal framework that integrates automated tools into tax administration without compromising fundamental legal safeguards. Second main problem is the black box nature of many AI systems. AI models are not open, transparent, and this opacity raises serious concerns for democratic legitimacy. Individuals subject to algorithmic decisions have the legitimate right to understand how the system works and what factors are used and how it affects their legal and financial status. And this is not just a procedural matter, it reflects a broader democratic principle. People must have a say how they are governed. And when taxpayers can't contest or understand algorithmic outcomes, the public authority loses its accountability and taxation loses legitimacy. And in terms of recommendation, a strong example of how this is being addressed comes from Australia again. The NTO is working on open source algorithm, allowing citizens to see which criteria trigger a high-risk label. It's transparent. In their website, you will see the algorithm and you will know under which criteria you are assessed risky or not. And third, we face growing concerns about privacy and surveillance. Tax authorities now collect enormous amount of data, personal data ranging from financial transactions or even behavioral indicators. And they even take data from web and social media, and this raises a crucial question. Where do we draw the line? Do tax authorities need to know my income and my expenditure? Probably yes. But do they need to know if I'm pregnant or not? No. Do they need to know the websites that are visited? Do they need to know which political party that I'm supporting? No, they don't need to know that. Definitely not. So we must ask, does the public interest in tax enforcement justify unchecked access to personal data? Even routine practices like accepting cookies can cross privacy boundaries and misuse. I believe similar principles should also apply for revenue administration. Proportionality is an important principle in data protection, and data collection must be limited on what's necessary. And additionally, because of the nature of the data, they are very sensitive, cybersecurity must be a top priority. But when we look at the current legal framework, often we see that they often fall short. For example, GDPR allows broad exemptions to public authorities. And similarly in Turkey, data protection law, there's a huge exception for public authorities. They can process our data, they can collect data, and it's under the exception. So what can be done? I believe the exception for the public authorities should be restricted with the proportionality principle. And there's a slightly similar example in Abdurrahman. So lastly, a balance must be maintained between efficiency and other fundamental public values such as rule of law, democratic legitimacy, taxpayer privacy, and public trust. While efficiency may be the main goal of the private sector, in public sector, in public law, it should be considered alongside with the other values and principles like legality, transparency, and institutional accountability. One last point, I believe ex-post remedies are not enough, as we experienced in the Dutch child care benefits scandal. We must implement ex-ante safeguards, as I mentioned in my presentation. before harm occurs. Thank you.
Thank you very much, Professor. Just because we are running out of time, I will give the floor to my colleague, Professor Dr. Abdurrahman SAVAŞ, from İstanbul Üniversitesi, ŞAHİN, Department of Thank you very much. The floor is yours. And you will have time.
First of all, I would like to thank the organizers and the manager for giving me this opportunity. It's a pleasure to be here. Our presentation with Associate Professor Abdurrahman SAVAŞ is about consumer protection in AI-driven telematics insurance. It's a deep kind of product that utilizes or increased ability to both collect and process vast amounts of data. This particular insurance is becoming increasingly popular, especially among younger generations, and it's projected to be even more widespread as our technology advances. It has several benefits for society as well as the risks and challenges that we also heard about several times in this symposium. So we will try to approach this topic from a consumer protection perspective and try to lay a groundwork for future regulation of AI-driven insurance products. What is telematics insurance? Basically, they put a sensor in your device, and this sensor collects data about your driving characteristics, and this data is processed by advanced data processing tools and, of course, artificial intelligence as a natural application here, and it's also widely used. And they use this data to make a risk assessment of your driving behavior. And with this risk assessment, they can offer you more personalized insurance products. For example, they can offer you discounts, or they can offer different clauses for your motor vehicle insurance. And this process doesn't stop after signature. This is a dynamic process because the sensors constantly collect data and it's constantly being processed, and the AI learns from your previous behavior to make even more accurate predictions. What is different from the traditional motor vehicle insurance? In the past, because the insurer doesn't have the ability to monitor your behavior, they use statistics to calculate the risks and the pricing schemes. They pool you in large consumer pools, and they segment these pools based on the data they have and then use something called low on big numbers. Basically, they use statistics to calculate the risks for the group, not an individual, so it was a collective effect. But now, since they can follow individual behavior, this process of pooling and segmentation, it becomes much more precise, much more granular, and the products can become much more individualized based on your risk, not as a part of statistical calculation. What kind of data is collected? They, of course, collect traditional data during the underwriting. Also, they collect data about your driving habits, your mirroring, your trip times and duration, your driving frequency, location sometimes, what kind of data, what kind of roads that are you driving, urban roads, rural roads, whether you are driving at night or the day, etc. They also can collect data about your driving behavior, actually how you drive, your acceleration and braking patterns, your cornering, your lane changes, whether you are speeding or not. They can also collect some fatigue indicators if proposed, if presented to the machine, like long uninterrupted drives. Please keep this distinction in mind because this will be very relevant later on when we are talking about the risks. What kind of benefits we can get from this particular insurance scheme? The most obvious one, it gives drivers actual incentive to drive safely, because now if they drive safer, they can get much better offers from their insurer. And this is not an estimation, by the way. we actually have some empirical data made on more younger drivers. This financial incentive and dynamic feedback from insurer via smartphone applications actually increase their driving safety by a significant amount. So this is a net boost for general society because it will encourage more safer driving behavior. Another advantage is solve the problem of misclassification both for insurer and the consumers. Insurers can group people much more precisely according to their actual risks. So for consumers, now they will not have to be compensate higher drivers, even they have much safer driving behavior just because of their same customer segment. So it actually rewards you for your driving behavior, and it's much more fair result, in my opinion. Of course, there are also some challenges. You will see there is similar themes going on here: the black box problem, the opacity of the AI, and the lack of transparency and accountability, especially in complex products like this. Also, there is a obvious potential for privacy violations, especially for the models that actually use your location data and your driving habits. And this particular habitual data is problematic because they may create some socio-economic exclusions for already disadvantaged, financially disadvantaged people. What do I mean by this? For example, think of a neighborhood that is more lower income, that has a worse road infrastructure, and machine will automatically flag it as a high-risk area based on the model. Or for night driving, most models they consider night driving as more dangerous, and think of a night shift worker. These people will have the risk of being excluded from these essential services based on their, not on their actual driving behavior, but this is how they live. So there is a risk of that. The risk of data bias also applies here. Initial bias in training data can be amplified by constantly training from the outputs and again the inputs. These are the main problems, but another very critical problem that we would like to address is something called discrimination by proxy. This is the definition, but I would like to explain it briefly with an example. Think of this as an intersection, a very badly designed intersection because of the municipality's fault. And I think there's a religious institution here, like a Shintoist temple. Okay? Because this place is so badly designed, a lot of accidents happen here. And the AI can understand that this is a hotspot for accidents. So it will start consider drivers who frequent here more risky. And who would more frequently be around a Shintoist temple? Shinto people, the people who practice that religion. So the machine can make that correlation, but cannot do that, cannot understand the causation, and it will not say Shintoist people are bad drivers because this data has never been given to them, but it can infer from these two variables to create a discriminatory variable beside. So this is a really possible risk that can need to be addressed. Before continuing the consumer protection, I would like to introduce a new area of AI research that is called Explainable AI. I believe it deserves more attention from legal research. It mainly focuses on making AI decisions understandable and transparent, especially in sensitive and regulated fields like insurance or financial technologies. It's about designing systems in an understandable and interpretable way, or designing specialized tools that can understand or explain the other more black box models. It is also conscious of whom we are making the explanation. So an explanation to a consumer cannot be same for an explanation with a system engineer or an auditor or an expert who is looking at the case in litigation. So this is very, very important, and we will give examples on this experiment AI tools. There are two models that we would like to talk about. They are called SHAP and LINE. They are model agnostic, which means they are separate models and they can understand and explain the main model that is actually making the calculations. This example, like we give them a simple question about an output, why my premium has increased. SHAP will give value to each variable and explain it. And LINE will list the most powerful variables that have impact on that particular outcome. These are both post-ante explanations, like they explain the outputs. So we have our problems and maybe our vehicle. How should we regulate this consumer? How can we protect consumers in this digital products? It's also that today, with a complex product like this, it goes beyond guarding against harm and discrimination. It should also cover the whole process that the policy is active, and people should really understand the consequences, the economic consequences of these particular products. To address this situation, we need to give clear information to consumers at every stage and have a strong governance framework for insurance, and we have some explainable AI solutions to address these problems. To materialize what did I do? For example, the disclosure requirement is one of the main pillars of consumer protection, but in a new and complex product like this, in order for consumer to really understand the economic consequences, you must be given information about the default premium, because before giving all this data, you should know what would his or her premium would be. Each data collected and their impact on their risk assessment, because not every model uses all kinds of data. Some specialize more in location and driving frequency, others specialize more on their driving behavior, so they have right to know about them. Also, this is a legal requirement. They should get information about safer driving, but not general rules. But this particular model considers a safer driving. This is very, very important. We should always be conscious about what kind of model we use, and consumer must always know about this. They should know about discount, or if applicable, extra charges applied. And very, very important, they should know about if there is an actual driving habit that's considered high risk. For example, if I'm a night shift driver and the product I am buying use a model that deems night driving risky, I should know about it beforehand, so I wouldn't buy it. Same applies for people living in certain neighborhoods or in rural areas. And of course, they should know about their right to have an explanation and contest every decision made by the AI and decision making about themselves. How this information should be communicated? The old practice is not sufficient here. In my opinion, it wasn't sufficient back then also, but now the risks are much higher, so this digital products should also use this power to explain, actually have an interactive, user-friendly interfaces that can actually, the consumer can look at with, explain with some charts or infographics, graphics, to make him really understand in a plain and intelligible manner. Also, these solutions, these mobile applications mainly, should provide dynamic feedback. And this duty of disclosure must extend beyond the signature, because the economic consequences constantly shift based on how the consumer drives their vehicle. So, for example, explanations must be precise and give actual data on what's the problem. For example, if I ask that machine, why am I driving score 3, why am I paying more? The answer like, because you accelerate too harshly, you brake too much, you are speeding. These are the explanations. And true explanation, a legally satisfying explanation must be precise. When did I did that? what was my mistake? In which location did I do that? So only then I can exercise my right to contest each individual decision that is made by AI. This is very, very important. This would satisfy both explanation, right to explanation, and right to contest decisions made by AI. And the last topic should be about governance. The governance framework had already been widely discussed here. A particular thing I would like to emphasize on. We think this would be a powerful tool to combat this discrimination, risk of discrimination and biases, because it is not understanding that if there is a discriminatory result going on for certain people, it will show themselves as statistical anomalies, which can be audited from outside, can be researched on, and maybe cross-check if they actually coincide with facts or they are actually based on discriminations made by the AI. So the auditing here and supervision is very, very important. We believe that all stakeholders that have an interest in this products should be made aware of some anonymous statistics about each product's outcomes and the usage. For example, there are different frameworks proposed. Some emphasize more on internal protection, internal audits, also more European Union and some United States organizations apply this to more regulatory bodies, some supervision, oversight and supervision rules for regulatory bodies. Also, there should be some transparency and cooperation data sharing with consumer units or industry associations, also with academic and independent researchers, so they can also make their research on these particular issues and understand if there is something wrong with the statistics. The last point I would like to make, as you understand, I think a model that uses behavior data is good, but behavioral data is the actual problematic here. So maybe the governance framework can be designed in a way that the more models use behavior data, the more likely the governance requirements can be, and so this can give the companies maybe a financial incentive to create or use that tools that doesn't use very risky data like location, but actually focus on the tools that emphasize behavioral data. I hope it was informative. Thank you very much for listening.
Thank you very much for this speech and reflecting time. And we got a little bit late, but I think we have 10 minutes for the audience to make questions or brief comments. Yes, can you also introduce yourself and address your question? Thank you very much.
Associate Professor of Civil Law, Assoc. I'd like to address my question to Professor PONCIBÓ, if it is possible.
I think it's possible, technically. Professor PONCIBÓ, can you just hear us?
If not, I will ask you, Professor.
Kutuba bakabilir miyiz burada? Yes. Yeah. Professor PONCIBÓ, can you hear us? No? Yes, she's actually online. Yeah. I will try again. She's muted, but yeah. Okay, let's try. Otherwise, we can ask the question.
Okay, she's on the Okay, I'll ask my question, maybe the panel can answer. Actually, when it comes to the liability caused, because of the damages caused by AI systems, two main grounds of liability are available: product liability and contractual liability. In the case of European Union, revised product liability directive is the main source of liability. In the case of large language models, actually, I wonder if definition of defect is compatible to hold somebody liable. For example, in the case given by Professor PONCIBÓ, defect is defined as not meeting the reasonable expected safety standards of a product. Actually, these large language models are by itself have this problem of hallucinating, and they are having this low standard of safety. Actually, it is their standard of safety. And if this model is hallucinating and causing harm to somebody, is this a defect? Because by itself, this defect or these hallucinations are embedded in the systems. Actually, if we can define this as a defect, I would like to ask if these hallucinations can be defined as defects. And in the case of contractual liability, actually, we are signing user agreements, and contractually, large language models are not promising 100% true information. They are not saying, they are on the contrary, they are saying sometimes we do not provide accurate information, therefore you have to check. Otherwise, you have to consult legal professionals or medical professionals or other professionals. In this case also, can we argue there is a violation of contract if the large language model is providing the wrong information and causing damage? Could you please clarify if there is a contract violation or it can be defined as a defect?
Anyone? I mean, contract, propagation and defectness, I mean, it's a huge problem on legal regulation of product liability also. And that's why I think the report of the new regulation of product liability is to define defectness for the AI, for the digital age. And, but I'm not a big expert in the she can hear us. Otherwise, contractual liability depends on the contract. And especially if there are some clause, I mean, explicitly saying that they are not wrong. And I think violation of contract, I cannot answer correctly just because we should see the contract. But probably, I mean, can be done. But defectness is a huge problem to define it even in the normal age, in a digital age, it's even than that. But I mean, as a chair, I don't know if I answered the state of things. And otherwise, some other comments?
Another question, but to add to Professor's question.
Yes, I do.
Once again, hello. There are specific provisions in the AI Act which state that there are some data governance obligations and a risk framework which also lawyers should apply. And it says that possible use scenarios, but also misuse scenarios of these models shall be taken into account. That means a large language developer must also take into account that this application could be misused. And these are not extreme cases, but possible foreseeable misuse cases. So a classic developer cannot say, oh, you have misused this program, it was not foreseen for the purpose it was brought to the market. and this is a misuse, and I'm not responsible at all. That's not possible for these developers. Against this big background, you can say that possible misuse scenarios are not excluded from liability. However, if you write this in the contract, I mean, these are classical terms and conditions, usage conditions, and if you say that this is this deviates from the law, and there we are in the field of what is the connection between product security and contractual liability. And we can say that product security says you must establish a data governance framework, a risk framework, where you have to take into account all these misuse cases. And now you can also not exclude liability in a contract contrary to product security law. But of course, the relationship between product security law, product liability law, and of course contract law is not very clear. But there are already concepts in the AI Act which regulate these fields, this problem of misuse.
Professor. Any other questions?
Hello, this is Hukuk from Boğaziçi University. I'd like to ask, first of all, thank you for the presentations, excellent presentations. I'd like to ask questions about the AI using the tax law. So it's obviously that you mentioned that human in the loop should be considered, but in the case of, I think we have seen some examples from Pennsylvania child care services as well. Like the human in the loops can also have biases. Like when the AI says you should do this, humans usually think that it should be right. And AIs obviously have complex algorithms, etc. How is that possible to think that AI is also could be wrong and could still be critical in the thinking? Because otherwise it may have goes to the direction of rubber stamping every decision that AI is made already. And also, how can we solve the problems of false negatives? Thinking that AI auditing a company saying there is no tax fraud whatsoever, the AI is pretty sure there is no tax evasion, but how can we prompt a tax audit nevertheless on that company or the people? Thank you.
Thank you for your question. When I mentioned human in the loop in my presentation, I mentioned two dimensions of human involvement in AI lifecycle. And the first is when first the data is entered into the AI. When you train AI, you need to keep someone responsible, keep a tax official, specifically someone responsible for entering this accurate data into the system. And the second dimension of human in the loop means that somebody should be constantly detecting the system if there's something wrong. For example, when I mentioned about the Netherlands child care scandal, there were 94% false negatives. If there was someone in the loop, obviously he or she definitely can see this anomaly and correct it during the process without that huge violations happening. So there are two dimensions in it.
Yeah.
Just responding, we talked about it already privately. We should not forget the role of the judiciary. So in the case of the Dutch scandal, because it is the way it is now, the judiciary afterwards apologized. And they apologized because in administrative cases, they normally argue very formally. It's very different from civil cases. And they say, well, we we do not have the knowledge to understand an AI framework, but we should have understood that given the cases that came up, so let's say the objections and so on, the decision is wrong and so on, we should have been far less formalistic than we normally were in administrative cases. We should have discovered the pattern. There was a pattern of mistakes. And in fact, they apologized. And they, I must say, it was quite a shock also to the judges that they had not seen this happening in front of their eyes. So I think we should never forget, we can talk about organizations authorizing the use of AI before it is used, but never forget the role of judges and the responsibility of the judiciary, because that is a traditional organization we have to check afterwards. And as you say, once all the damage is done, undoing it is just horribly complicated, and you can never really do justice afterwards.
That's something, and I believe while the Dutch Revenue Authority made serious mistakes in applying this discriminatory algorithm, I believe they also provided an exceptional example of political accountability. So in response to the scandal, the entire cabinet collapsed, and they resigned, and several public institutions publicly acknowledged that they share the responsibility, which shows the political accountability exceptional way. I know many countries won't do that, so that's a great example of accountability.
Thank you. One last question. Okay. We have finished all the sessions, and after lunch there is a round table. There's still 1:30. Okay. Thank you very much. It was a very